This video is designed to assist you in creating an employment contract for an agricultural employee. As part of the video, we will walk through a contract template, allowing you to familiarise yourself with the sections of the contract. We will focus in on the areas of higher complexity, assisting you with information that can help in completing those sections, and also things that you should consider or research before you sit down to complete the contract. We won't go through every section in detail, as some things are very straightforward, such as start date and location of employment. The video will be broken down into 3 sections which fit with the headers in the employment contract. And those are wages, hours and holidays, sickness and pensions, termination, notice and disciplinary. The majority of written particulars must be provided on or before the first day of work. Now please note this changed in 2020, so if you're looking at any older resources or also in places that contract template may still make reference to the old rules, so please note that now it is the majority of written particulars on or before the first day of work. The old rule of having 2 months to complete an employment contract still applies for some very specific items on the contract, but not the contract as a whole. So those very specific items which are exemptions to that rule, they are items around pensions, training entitlement and some of the disciplinary and grievance procedures. So you have a bit longer to provide those. They can be provided within 2 months of the employment beginning, but for the majority of all the other items on the contract, you need to have that in writing in a document on or before the first day of work. Where a change occurs on anything that is covered by the contract, you need to notify the employee in writing. Now you should do that as soon as possible after the change occurs, but at the very latest you must do it within 1 month of that change taking place.
So before we go on to our first section of wages, hours and holidays, I'm just going to scroll through the example contract to allow you to see the easy terms and statements that come before that. So it's employer name and employee name, the date the employment began. Please note there is an option for continuous employment, however this will not apply to all that many people and you only need to enter this section where applicable. So this is where previous employment with a previous employer is counting as being part of the period of continuous employment that you are employing that worker for. Job title, you need to give a job title to what you are employing the worker to do. And then we reach wages. Within the contract, there is a need to state what the rate of pay will be. For agricultural workers, there is a minimum hourly rate that must be paid, and this differs depending on which category workers fall into. So there's the minimum rate for all ages of workers, but that is slightly different if they are an apprentice and there's certain timeframes of which you can pay a slightly lower minimum rate while they're on their apprenticeship. And then for workers with qualifications, there's a top-up rate that they can have applied onto that minimum hourly rate for all ages of workers. These minimum hourly rates change every April, and the Scottish Agricultural Wages Board produce a useful guide for employers to explain these rates. And this guide can be found online. It is perfectly acceptable to charge more than the minimum wage or minimum hourly rate for that category of worker, but it is not permissible to charge less. And the one exception to this is that the provision of a house can be counted as part payment of the minimum wage, and that is the only benefit that can be counted as part payment. So the provision of a house can bring a worker's wage to beneath the minimum, but there is a maximum value in which you can place on that provision of a house. And the value of this is £1 per week. And that is the maximum amount that may be deducted from the worker's pay. Hours is the next section. When deciding how many hours you would like the employee to work before you enter it onto the contract, please consider when do you most require their support? How many hours can the business afford to pay? And when calculating what you can afford to pay, please remember that overtime does apply and ensure that you count in overtime hours. So there's 2 categories for overtime and I'll break that down for you now. So for the first 26 continuous weeks the employee is with you, overtime must be paid when a worker works more than 8 hours on any day or for more than 48 hours in any week. Once they have been with you for more than 26 continuous weeks, overtime must be paid when a worker works for more than 8 hours on any day or for more than 39 hours in any week. The minimum hourly rate of payment for overtime, and that's for both categories regardless of whether they are up to or over 26 weeks service, is the minimum hourly rate of pay to which the worker is entitled. So that could be the minimum rate including the qualified workers top up, multiplied by 1.5.
Also, when thinking about hours, bear in mind the weekly limits on working hours. So the working time regulations state that a worker cannot work more than 48 hours in a week over an average 17-week period. Now, there is a rule that the employee can state they're happy to work more than that, and you can go over that limit, but in that situation it must be agreed in writing, signed by the employee, and at any point the employee can bring that agreement to an end.
And holidays is the final part of our first section. The holiday year for agricultural workers is set as the 1st of January to the 31st of December. Holiday entitlement depends on the number of days that an employee would be expected to work in the course of a regular working week. So for example, a worker who works 5 days per week is entitled to 28 days of leave per year. And in addition, they would also be entitled to 2 special holidays for Christmas Day and New Year's Day. And please remember to include those special holidays and reference those within the contract. The Agricultural Wages Board Useful Guide for Employers is where I would recommend you consult to get the number of days of holiday entitlement per the number of days in a week that a worker works. There's a really handy, easy to reference table in there that will give you those base number of days, and you can then add on the special holidays. Please note, when calculating holiday allowance, if an employee comes out at all on the weekend, even just to feed stock in the morning, this counts as a day. So when you're looking at that table in the Agricultural Wages Board guide and you're thinking, well, how many days does my worker work, or am I planning to have them work? Please note that coming out at all on a day counts as a day. So therefore, a worker who maybe works every second weekend, so works both the Saturday and Sunday one weekend and then no days of the weekend the next week, they would be classed as a 6-day per week worker for the purposes of the holiday entitlement calculation. And the final aspect you must reference in the holidays section is holiday pay. The rate of holiday pay due is equivalent to an average weekly pay for a worker. So where you need to calculate this, then to get a week's pay, you would take the average hourly rate of pay, and that would be in respect across the previous 52 weeks. So it would be averaged across 52 weeks to get their average hourly rate, and then multiply that up by the average number of hours they work in a week to get your average weekly pay. One point to note that is if overtime is regular and workers are regularly getting it as part of their weekly or monthly pay, then it should also be included in the holiday pay calculation. So for example, that might be somebody regularly working 1 hour per day that is paid at the overtime rate. That payment should also be taken into account when calculating their holiday pay. However, if you are unclear on your obligations with regard to overtime and holiday pay, you can seek your own legal advice. The next section we will look at as part of the video is sickness and pensions. So starting with sickness. It is acceptable to state that it will be the agricultural sick pay conditions set out in the Agricultural Wages Scotland Order, unless you wish to offer any additional sick pay benefits that are not covered by the Wages Order. The Wages Order criteria states that a worker must have been in continuous employment with the same employer for at least 52 weeks to qualify for agricultural sick pay, and the minimum number of days of sick pay to which a worker may be entitled to in any period of 52 weeks is calculated by multiplying the number of days they are contracted to work in a week by 13. So therefore, a worker who is contracted to work 5 days a week would be entitled to 65 days sick pay in any 52-week period. Pensions is the next section in the template. Employers are required to automatically enrol eligible employees into a workplace pension scheme. This means the employer must add employees who meet certain requirements to the pension scheme. Therefore, if your worker is at least 22 years old but is under the state pension age and earns at least £10,000 a year, then you will need to provide a pension scheme and automatically enrol them in the pension scheme. So please note where it says there is/is not a pension scheme, don't simply just answer that without first looking into the exact criteria of automatic enrolment in pensions and where your worker would fit within that.
If you do not already have a pension scheme to add the worker to, then you can select a pension scheme yourself. And you'd be looking for a scheme that was set up for automatic enrolment, suitable for your business size, and also potentially compatible with any cloud-based accounting or payroll software that you are using. If you're not confident to do that yourself, you can seek advice from a financial or pensions advisor. As a supplementary document to the employment contract, you could include the terms and conditions of the particular pension scheme that either you currently use for the business or that you select to use for this employee.
Now please note, this template example is a few years old now, and the reference to contracting out of pensions has not applied since 2016, so this statement should simply be deleted from the template. The final section that leaves us to cover is termination, notice and disciplinary. So, termination of contract. Under this header, there are 3 options depending on the individual situation with your employee. They can be on a fixed term contract, and you can set a date on which that employment will terminate. Or you can state it is not intended to be permanent, and it's only going to continue for X number of weeks. Or if neither of these apply, you can tailor this section to suit you, and you could make a note that the contract is permanent and has no end date, and go on to explain how an employee should provide their resignation should they wish to terminate the contract. For example, you might want to add if you want it in writing or if verbal is sufficient. For the first line in regard to notice, this relates to how much notice you must give your employee if you choose to end their contract. The notice period they are entitled to is dependent on how long they have worked for you. Therefore, it is difficult to write this into a contract as a number of weeks, as it will vary throughout their time with you. However, you could state that they will be entitled to the statutory notice period in line with their length of service. Where employees have worked with you for 1 month to 2 years, that statutory notice is 1 week. For service between 2 and 12 years, statutory notice is 1 week for each full year they have worked with you. For example, an employee working with you for 10 years and 4 months would be entitled to 10 weeks notice. Once service is 12 years or more, statutory notice is 12 weeks. The second line is for the amount of notice you would like the employee to give should they choose to resign. For this aspect, consider how much time you would need to make alternative arrangements and ensure that workload could be covered. And finally, we will move on to disciplinary. It is necessary to have disciplinary information in the contract. Essentially, what is meant by disciplinary procedures is what process you as an employer will follow should you need to deal with misconduct. ACAS provide a code of practice on disciplinary and grievance procedures that is the minimum an organisation should follow. In summary, a disciplinary procedure would involve formally notifying the employee of the issue, either in a written letter or email, before conducting an investigation to gather as much evidence as possible regarding the employee's misconduct or poor performance. All evidence must be shared with an employee, along with the potential outcomes, before you sit down together to discuss. The employee has the right to be accompanied to this discussion, and it is from this discussion that the employer must reach an outcome that is fair and reasonable based on their findings from investigations and meetings. The other two aspects in this section of the contract are who employees can appeal to if they wish to appeal the decision, and also how such an application should be made, letter, email, etc. Similarly, for the grievance line, it's who the application should be made to and how it should be made. Finally, within the contract, there is an Other Terms and Conditions section, which allows you to add anything that has not previously been covered or is specific to the job you are offering and you would like to have noted down in writing.
Once all the information is entered onto the contract, you should sit down, go through this with your new employee and both sign and date it at the bottom to confirm that you are all agreeing to the terms included within the contract. The sections of this video have been labelled to allow you to easily navigate back through this video as a resource when you come to sit down and complete an employment contract. FAS have a range of other resources relating to employing people, and we have linked these in the description of the video so that you can easily access them if you're interested in other aspects that we have covered through other materials.